you knew going into this process that the longest part of it would be the period of time that the probes were hybridizing.
Oh, no.
Yes. You knew that that part of the process would take something on the order of 15 days.
I just did that. But luckily Josh isn't here today. Hi guys. It's Kathy. I hope you're doing well. Time for OJ. Before we know it, very soon, not today or tomorrow or this week, very soon they're going to start closing arguments. Is that not crazy? That's crazy. It's crazy to say, but all right, here we go.
16 days per probe, given the small amount of high molecular weight human DNA you had.
Well, I think it was in mid-May that I informed the court that I would need about 2 months.
Please answer my question.
Well, I'm trying to use that because you're giving me a specific...
I'm giving you a very... I'll do it, make it easier for you. All right? By March 22nd, you had done the quantitations on the combination and knew that you had 72 nanograms of high molecular weight human DNA from 303, 304, and 305, right?
No, that's incorrect. I didn't know as of March 22nd that that was human DNA.
All right. You're saying you knew you had 72 nanograms as of March 22nd, right?
Yes.
And then by April 4th, certainly, you knew that that was 72 nanograms of high molecular weight human DNA.
Yes.
But it would be a fair statement that certainly by March 22nd, you knew if you only had 72 nanograms of, at best, human DNA, that the RFLP tests here would be longest in terms of elapsed time from the moment that that probe began to hybridize, right?
Yes.
So you knew that would be the long part of the process that would drag it out.
Yes.
And if you wanted to get this done in a timely fashion before the end of the prosecution's case, you had to get the probe started right away, correct?
Overruled.
Well, I don't think I had any idea of how long the prosecution's case would be at that point in time.
Were you aware that when the court ordered that this combination could take place, that it was the understanding stated in open court that this process of RFLP testing should be done immediately, if not sooner, quote unquote?
I don't recall that exact language, no.
Nobody communicated to you that this court said that it was its understanding that the RFLP process for the combined stains should begin immediately, if not sooner?
Well, I know that the prosecution, which would be through Mr. Harmon, encouraged me to get this done as soon as I could, yes. But I don't recall the court ordering that.
In your discussions to get this done as soon as it could be, did you inform Mr. Harmon, as of March 22nd, when you knew you only had 72 nanograms of DNA, that the long part of this process would be the time that the probes began to hybridize?
Well, we've asked that question already, haven't we?
I just want to establish that Mr. Harmon knew.
I think we can assume Mr. Harmon knows how the process works.
I think he does, but I guess it's just for the purposes of the record. We all know he knows.
All right.
Now, in terms of this process, and I call your attention now to the questions that Mr. Harmon was asking you about the process that you prefer to do over 3 consecutive days involving the restriction analytical gel and southern blot. Now, the restriction, all we're talking about is putting that DNA into a test tube with the restriction enzyme and cutting it up, right?
Yes.
And that, in terms of hands-on work, that takes, what, an hour?
Something like that, something along that line.
And then you just let it sit overnight?
Yes.
And he was asking you questions about how you prefer to do this over 3 consecutive days, but you didn't even do this over 3 consecutive days.
No, I think that misstates my testimony. What I said was that when you can do the restriction separately and then set it aside. The 3 consecutive days are you do one day where you do the analytical gel overnight, the next day which is the electrophoresis, then the next day is the southern blot overnight, and then there's a third day where you have to dismantle the southern blot. So that's the 3 days that you need in a row that I spoke of.
All right. So in terms of the restriction, it's 1 hour of hands-on work, and then you leave it overnight.
Well, I would object to that characterization of 1 hour of hands-on work because it's not just hands-on work. It's evaluating how much sample you have to put into this situation. In this particular case, it's making sure we have enough sample, that sort of thing.
Wait a second. You just told us a second ago to do the restriction. It took an hour of hands-on work. Just a second ago you said that.
Well, no, I agree with that being an hour of hands-on work, but I'm
That's
saying
all I'm
there's a lot
asking you.
more than hands-on work, is my
Thank
point.
you. And then you let it sit overnight. The analytical gel, agreed that's 2 hours of hands-on work, and then you let that go overnight.
No, I
How-
disagree.
All right? How many hours of hands-on work does it take you to put the DNA into the analytical gel? Because that's what's at issue here.
Well, no, I don't mean to be argumentative, but I think you have to remember that after you've restricted the DNA, you have to do an evaluation. You run a digest gel. You have to then,
Just give me an estimate of hours.
well, that's
Prepare the
about a day's work, about a day's work after you do the restriction to get it now going overnight on an analytical gel.
So you're saying it takes you a day to prepare the analytical gel? Come on.
Yes.
All right, 1 day for the analytical gel.
Counsel. No, it's not.
Well, very fond of Mr. Sims. Me no disrespect to him. I'm only trying to get at the truth here. Mr. Sims, the southern blot. How long does it take you to prepare the southern blot? An hour and a half to 2 hours?
After the overnight electrophoresis, it's about 2 hours of work then to set up the southern blot.
All right, so you can do the restriction, the analytical gel, and the southern blot in what, 3 days?
We're now through that process. Yes, there would be about 3 days, something like that.
So it would take you, and part of that, it's not just 3 days of consecutive work. Part of that is you just have to let things go overnight.
That's correct.
All right. So before you get to the phase where there's this long elapsed time of letting the probe sit, you needed to do essentially work that would take 3 days to complete, right?
Something like that, yes.
Well,
3 or 4. I'd like to say 3 or 4.
let's try 3 or 4 days to complete.
Yes.
But in those 3 or 4 days, for example, if you had done the restriction, which you told us takes about an hour, and you let it sit overnight, could have done the restriction in an hour and had a conversation with Mr. Harmon about discovery or preparation or other things, right?
Well, that's not really true because a lot of these things are done at the end of the day. For example, the restriction is usually set up as the last thing that goes overnight. So it's not the sort of thing where I would do that the first thing in the morning and then later in the day talk to Mr. Harmon. That's not clear.
Let's
All right,
get,
counsel,
I have
we're
one
gonna-
last question, Your Honor, that you may want to think about overnight, and this will be it.
All right.
From March 22nd, when you knew that you had 72 nanograms of DNA, and there would be a very extensive time period in the development of each probe, to the time that you went through what you described as the 3 or 4 day process that would be necessary to get those probes in motion, right? That's the time period, okay?
Okay?
So it's March 22nd, and you began that process of getting those probes, that 3 or 4 day preparation time to get the probes in motion. You began that on June 7th.
Yes, I believe that's the right day. It's June.
And
June
it's, your,
7th.
and it's your testimony that between March 22nd and June 7th, you couldn't find 3 days to get that in motion so that the RFLP tests on the combined samples could be ready before the end of the prosecution's case. Is that right?
Well, it's the point that I did not find that. I came very close to doing this at the end of April, but I was not, I did not complete it at that time.
And you're not the only person that was doing that, just so the judge understands. In terms of these batch technicians, they're the ones that actually deal with the RFLP probes, technicians in your lab.
Yes,
And Renee Montgomery, she was working on this case too.
yes,
And she was doing PCR tests.
yes.
And she was helping with the RFLP tests.
That's not true.
She can't do any of these. Didn't she do slot blots and yield gels on some of these samples?
She did on some of the samples, but I don't believe she did any with regards to these particular samples, no.
All right,
She's
we'll stand-
capable of it.
All right, we'll stand in
Yes.
recess until 8:30.
Your Honor, could I just give the court, it might be helpful for the court, you wanted references to Dr. Purdy's testimony on the stains?
Yes.
Mr. Clark has been kind enough to write them down. He's not sure of the volume numbers, but he has the dates of the testimony.
All right.
Your Honor, there were 2 witnesses that the defense, without telling me about it or asking anyone, they went directly to the witnesses, Kevin Schott and Robert Lee, and told them that they had to stay until tomorrow at noon. Their flight is scheduled for 8 o'clock in the morning. They have had a full opportunity to interview those witnesses. Their testimony is complete in the people's rebuttal case. If the defense seeks to have them subpoenaed, they may do so, and I don't see any cause for them to be required to stay longer than their flight would indicate, and I'm asking leave of the court.
Mr. Sims, tomorrow morning 8:30. Thank you.
I'm asking leave of the court to let the witnesses go.
Mr. Scheck?
I feel like the court now. I've been here with you. I don't know what they're talking about.
Those witnesses were released from further testimony. There was no request to keep them.
Thank you.
All right, we'll be in recess 8:30.
It's going to be not 72 nanograms of DNA consistent with Mr. Goldman, but a much smaller portion.
That's correct.
And it's for that reason that you conceded yesterday that you would expect that once the process began of putting the probes, developing the probes, that it would take a considerable period of time to develop them because you knew that the amount of DNA that could arguably be consistent with Mr. Goldman would be a small contribution.
Yes, in
So-
other words, that these autorad development times would be prolonged because there was an overall total low amount of DNA, and since it was a mixture, then that would, any of those particular components would be even less, obviously, than the total.
Now, between the period of March 22nd and when you began the 3 to 4 day process of putting the probes onto the gels to develop them, okay, you went through some considerable discussion with Mr. Harmon here yesterday as to what your activities were, correct?
Yes.
Now, much of that time in April was taken up in discussions with Mr. Harmon in preparation for your testimony in this case.
There were a few meetings with Mr. Harmon on the, I believe it was on the Fridays of April, yes.
Well, it took you one day, April 5th, to prepare your report.
Yes, I logged 14 and a half hours on that day of report preparation. That was, in addition, there was some other work. There was the Sunday, April 2nd. Before that, there was also some time spent on the report.
Okay, so those 2 days, April 2nd and April 5th, that's what you took to prepare your report, which was a summary of your results.
Yes, and I believe there was some other time in there also, where I was doing some word processing, putting things together. That's all part of that mix.
All right. And your notes, you've told us before, you kept contemporaneously as you performed your work in this case.
Yes.
So in order to turn over to the defense discovery of the notes, all you had to do was take your contemporaneous notes and Xerox them and turn over a copy, as far as the notes are concerned.
Well, as far as the notes, we make copies. We have a special numbering system we follow. There's preparation of correspondence. There's sometimes taking it to the Federal Express office is something that I would do. There's a lot as far as making sure the autorads get copied and numbered. And the discovery process is not just a matter of sticking some pages in a Xerox machine and walking away and coming back and having them ready to go.
You turned over to us your notes, which you kept contemporaneously, and the autorads, which were being produced on all the other material that you testified about in this case as you went along.
Yes,
In other words, before you're reporting the results, you have to look at the autorads.
that's correct.
So in terms of the discovery, all you ever turned over to us were the autorads and your notes, right?
Well, there are my notes, there are other analyst notes, and there are also review notes and that sort of thing. There's a whole package, and you received several of
Yeah.
those, so you know what's in them.
Right. But you've indicated here that you spent all of April 10th and all of April 11th engaged just in discovery preparation.
No, what this indicates is that as far as those 2 days are concerned, I did spend almost all of April 11th. I have 8 hours I logged on discovery prep. On April 10th, it was only 3 hours, so I was apparently doing something else on April 10th.
Now, then you have on Wednesday and Thursday preparation for testimony, correct?
Yes, I believe that's the 13th and the 14th.
All right. And so those are at least 2 days that you spent with Mr. Harmon preparing testimony.
No, a lot of those times are just my own time spent. That's not with Mr. Harmon at that point.
Okay. And what about, incidentally, after you prepared the report on April 5th, on April 6th, you and Renee Montgomery actually flew to Los Angeles to give the report to Mr. Harmon.
Yes, and to consult, yes.
So on April 6th, you consulted with him in preparation for your testimony in this case?
Yes,
In Los Angeles?
yes.
On April 7th, I take it you did the same thing, even though it's not listed here?
I believe that was a Friday.
A Friday.
I think that's incorrect. I think I came back sometime in the evening on April 6th, and I'm not sure what I did on April 7th. Apparently, it didn't relate to anything on this case.
All right, so you didn't do anything on the case on April 7th, but you did other work?
Yes, I put in, I believe, a full day at work that day.
All right. So on April, what about Wednesday, April 12th? Was that another day that you were preparing for your testimony?
No, I didn't log any hours on this case for April 12th.
So April 12th, you didn't do anything on this case?
Well, I won't say I didn't do anything. I may have been developing an autorad, for example, but I have no mention of it in any of my timesheets that I could find.
All right, so April 13th and 14th are other days that you're preparing testimony?
Yes,
April,
you mentioned those earlier, yes.
Then you put down here April 17th and 18th you're preparing for testimony?
Yes,
Is that you spending time with Mr. Harmon?
no.
That's all day you're just sitting around preparing for testimony?
Well, on the 17th, I believe there were 2.5 hours, and then the next day was a full 8-hour day on preparation.
And incidentally, getting back to this before, the 3 or 4 day process that you describe as being necessary to get those probes going, that is not 3 or 4 days of hands-on work by you.
Well, all the hands-on work is by me, but it's not full 8-hour days.
Right. Not full 8-hour days by any means.
Well, one of those days is virtually a full 8-hour day.
But as you described before, the restriction takes an hour, and then you just let it go overnight.
The hands-on time that I would mention would be the actual adding of samples and
Yeah.
tubes, but there's also the planning stage in that, and that takes a considerable amount of time.
Well, you could put, I think you testified yesterday, it would take you, what, an hour and a half to do the restriction and put it overnight, right?
In this particular case, I believe there was some additional time in terms of the planning, but as far as the hands-on,
Give me the
that's correct.
total hours it would take you to plan and do the restriction.
In this case, I would say it was about a half a day, something like that, maybe
What's a
4
half a
hours.
day?
4
4 hours? You're going to get this 4 hours?
Something
Okay.
like that.
So you
That's
could,
approximate.
Excuse me. If you guys want to talk at the same time, we're going to stop the hearing right now.
so, if that takes you 4 hours, my apologies, Your Honor, if that takes you 4 hours, you could do that and then
Don't make
spend
me
the
turn
remainder
this
of the day
car around.
preparing your testimony, right? Looking over the materials.
Well, as I think I mentioned yesterday, the restriction is something that is typically done at the end of the day. So that's something that I would save that latter part of the day.
Okay? So you could prepare your testimony in the early part of the day by reviewing things and then start the restriction at the end of the day.
That's possible, yes.
And then, to get back to this, on April 19th, you talk about analysis of test results. Is that still more preparation for your testimony?
I think there may be some of that in there. There may also be some autorad development. Another thing that was going on at this time was there was some monitoring of some of the testimony of the other witnesses. So I'm not sure exactly what all was going on that
Well,
day.
let's get to that. In other words, part of what you were doing here is that you were listening to the testimony of other witnesses before you testified.
Portions of those testimonies, yes.
And were you listening on a radio in your lab?
At times I was, yes.
And sometimes you'd watch on television.
At times, yes.
All right. And then on April 20th, there was a whole day preparing testimony.
Preparation for testimony. That was, I logged, I think, a half day on that particular day.
On a half day, and was that alone or with Mr. Harmon?
That would be alone.
All right. And April 21st, you took off.
Yes, I took that Friday off.
And what about that Monday, April 24th? No work on this case?
I didn't log any time, no.
All right. And then on April 25th, you were reviewing other materials and preparing for testimony.
Yes, and at that point, I went back to the plans for doing the RFLP, and I made some notes that are reflected in my laboratory notes for that date.
Now, on April 26th, you talk about what Renee Montgomery was doing, correct?
Yes, and also that's the day that I actually laid out, and I'd hoped to do the restriction, and I think we alluded to this yesterday, that was the point at the end of April when I got very close to doing this, but I was not able to complete the restriction that night.
How long did you spend doing the restriction?
I logged a total of about 4 hours on the case that day, April 26th, which
Not my
was a
question.
Wednesday.
How long did you spend doing the restriction?
Well,
Planning the restriction.
The plan, I don't know the exact amount of time that was spent that particular day. It was probably on the order of a few hours, something like that.
A few? Planning the restriction? I'm asking you how long you spent planning the restriction.
I don't know exactly. I mean, I'm looking at my notes for that day. This is my notes on page 242.
Well, Mr. Sims, you mentioned that in terms of preparing the reference samples, you wanted to make sure that the reference samples would be in similar quantities to the amount that you had from the combined samples, correct?
That's correct.
So the autorads would look balanced in the lanes, right?
That's correct.
Well, and
I
so
can't help
basically,
you,
that doesn't
Dan.
take very long to do, does
I don't know where it is
it?
either.
Well, no, the difficulty here, and I think we got into this a little bit yesterday, but the difficulty was that I was running out of some of these reference sample extracts. And in particular, I had a note that I was trying to get more of the defendant's extract, and I had a note that I would check with Renee Montgomery to see if she had any sample available left over from some of her extraction. and this was one of these nights where it got to be, I think I logged out at 11:30 that night,
Are you talking now about, what date are you talking about?
April 26th.
All right, so April 26th is the time that you're first looking to see if you have sufficient amount of reference sample from the defendant to proceed with the RFLP? Is that what you're telling us?
That's correct. That's when I actually start handling the tubes again.
All right, so that's already April 26th.
That's April 26th.
So that's over a month after you have realized that you have 72 nanograms to do this RFLP, right?
That's correct.
And incidentally, so the judge understands exactly what we're talking about here. Basically, what you're trying to do is, you know, if you have something like 72 nanograms of DNA for one sample, instead of using 5 microliters of the reference sample, you'll knock that down to something like 1 microliter.
Yes.
That's a simple calculation you make on your handheld calculator, right?
Well, given the number of calculations I make in any case, I don't consider any of them simple, and I spend a lot of time with my calculations to try to make sure I get it right.
I understand, but it's just a simple question of reducing the amount of DNA from the reference sample so it roughly corresponds to what you think you have in the combined sample.
Well, I mean, you make it sound so simple, and when you look at it from your perspective, perhaps it is simple, but to me, it's a matter of making sure that I have how good are my quantitations, how good did they look on the previous set of autorads that I ran, that sort of thing, and making the proper estimates. And I take a lot of care in trying to come up with the best amount of DNA to use, for example. So it's not just a simple punch it into a calculator and get the result.
I understand, but you had 72 nanograms on March 22nd. Tell this judge, in all candor, how many hours it took you to figure out how much reference sample you would need to run, given the fact that you had 72 nanograms. The total number of hours it took you to make this calculation.
Now, this would be for April 26th.
No, I'm asking, how long would that operation take? Once you knew on March 22nd you had 72 nanograms, how long does it take if you decided to do it soon after March 22nd? How long would it take you to figure out how much DNA you needed from the reference samples to run on the RFLP?
Well, again, I can only speak in the context of the samples in this particular case, and it's not just a matter of saying I have this sample. I mean, I have this sample. How much of the sample do I have left? How did this sample look when I put it on the previous autorad?
Mr. Sims, taking everything into consideration, all the complexities and unusual circumstances of this particular case, how long did it take you to make the calculation regarding what size of a sample from the reference sample was necessary to do your testing in this case?
I think in this particular date, I spent a few hours doing that, maybe 2 hours, something like that, maybe 3, I don't know.
So in other words, if you sit down to do it, it's going to take you 2 or 3 hours, max.
Something along that line, yes.
And so the record is clear, you didn't really sit down to even do the planning until April 26th.
No, that's not clear at all, because I think if you look at my notes, the planning against, I have on April 25th, this is at page 242, plan for additional RFLP on April 25th.
Okay, so you started on April 25th, this 2 or 3 hour process, and it ended sometime on April 26th in terms of planning the restriction.
Well, I think you're simplifying the situation, and I can't give the precise number of hours that all these processes would take. But there is time on April 25th, and there's time on April 26th.
Right. Now, you then indicated that on April 27th, you're doing more preparation for your testimony and attending a CAC study group meeting?
Yes, that was on April 27th.
All right. April 28th, you're reviewing other data, but you're meeting with Mr. Harmon in preparation for your testimony?
Yes, and I also met with Dr. Blake that day, too.
On May 1st, you talk about in your notation, what Renee Montgomery did, right?
Yes, and I was working a little bit with her on that particular day.
How many hours you spent working on this case on May 1st?
I logged about 4 hours.
And what were you doing? Watching Renee Montgomery?
No, I think I was consulting with her on some stuff, and there's a lot going on at this point. Now, this is shortly before I come down to Los Angeles, so there's a lot of last-minute sort of things that are happening on that particular date.
All right.
I can only say that I logged 4 hours on that day.
And May 2nd, these are 4 hours on a photo log?
Yes, I put together, because there was a request for some of the photographs, I spent some time numbering and organizing the photographs that we took into some kind of numerical system.
These are the photographs that you took after Dr. Blake took photos?
Yes, most of them are after that, or made about the same time as Dr. Blake's photos. I also spent some time preparing to testify on that day.
Okay, so that's another one of those preparation for testimony days.
That's part of it, yes.
And these are the photos that
Counsel,
we've
is
never
there-
seen.
Isn't the issue how long the testing takes?
Yeah. Well, I'm just trying to...
Is there any dispute as to Mr. Sims' calendar here?
Oh, I just want to point out a few more things, Your Honor, in this regard. Now, you indicate here on May 3rd, May 4th, you're preparing for testimony, right?
Yes.
Saturday, May 6th, you're preparing for your testimony.
Yes, I also may have come in and developed an autorad that day. I'm not sure.
Now, you flew down on May 7th to watch Dr. Cotton testify, correct?
Well, I flew down on May 7th, which was Sunday, to, yes, I was standing, and also standing by because I didn't know how long her testimony would take, and I was requested by the prosecution to be here for May, what would that be, May 8th, Monday.
Well, wait a second. You didn't think that Dr. Cotton's testimony would take a few days, at the
Counsel.
very least?
Counsel, his presence here for the purposes of being with the prosecution counsel for the testimony of other expert witnesses, this doesn't tell me anything about the issue that I need to
Well,
resolve
I
here.
just want to make one point, Your Honor, in this regard. You sat in this courthouse watching Dr. Cotton's testimony on television, correct? Monitoring it.
I think I was at the hotel at that time.
Okay. Now, you had monitored other witnesses' testimony in your lab. At the same time, you're doing some work.
Yes, for example, there would be days when I would be preparing to testify and then I'd have my radio on, for example, something like that.
So-
I don't, may I finish?
Yes, I'm sorry.
I don't listen to the radio while I'm doing any laboratory analysis.
All right. But it is certainly possible for you at, let's say, the end of the day, for example, to have done the restriction and have monitored testimony during the day and been in telephonic contact with the prosecutors.
Is that possible? Yes.
Yeah. Okay. Now, there are other people. There's an individual in your laboratory named Steve Myers.
Yes.
Did he participate in creating some RFLPs in this case?
He was involved in some of the batch probing, but he didn't do anything as far as preparing the samples for RFLP analysis.
Is he qualified to do the restriction and prepare the southern blot and get those probes moving?
Yes.
And he was available to do some work on this case?
Well, he was available to do some work on this case, but he also has a number of other cases that he's working on. This was not the only case in our laboratory for this period of time, I can assure you.
But he's somebody that's qualified to do that?
Yes.
And did on occasion pitch in and assist you in RFLP work in this case?
Well, his main assistance was in some of the PCR testing, and I think we mentioned that earlier. He also extracted the hair sample, you'll recall.
But he participated in the RFLP. He does most of the RFLP work in your lab.
No, that's not at all
He
correct.
does a lot of RFLP work at DOJ.
He does a lot more PCR work than he does RFLP work. He did some of the batch probing because he's a very good prober.
Okay. All right, Your Honor, I think on this issue, I'm completed with my cross-examination, Mr. Simpson.
All right, Mr. Harmon?
Just a couple of questions, Your Honor. When Dennis Fung began his testimony on April 3rd, did you know how long his testimony would take?
No?
Was that one of the considerations in not knowing exactly when you'd be able to do the RFLP process?
Yes, because there were certain things that I needed to accomplish, I felt, before I would come down and testify.
Okay, did you expect the kind of long-winded cross-examination that occurred of Dennis Fung?
No?
Well, that's not really necessary.
Did you expect the kind of cross-examination that occurred with Andrea Mazzola?
Well, I think after I saw Mr. Fung's cross-examination, I expected some long cross-examination after that, yes.
Okay, did anyone discourage you from doing the RFLP results so Mr. Scheck could see them presented in the case in chief?
No.
Thanks.
Any recross as to that? All right, Mr. Sims, thank you very much, sir.
Thank you.
Mr. Harmon, anything else?
Bye, puppy dog. Bye.
All right. Mr. Scheck, do you have anything you wish to offer?
Yes, Your Honor. There's a few issues on the table. I have to respond. I take it, or I really think it's our motion. Initially, I want to
That's
make...
why I'm asking, do you have any evidence you wish to offer, any witnesses you wish to call?
No.
All right, I'll hear argument.
Your Honor, well, first, the first issue that I would like to address, Your Honor, are the points that were raised by Mr. Kelberg. I'll take them in order. And before even reaching, it's my understanding that the law with respect to rebuttal involves three factors, as we outlined them in our brief. Was it available, could it have been available in the people's case in chief? is the evidence important or crucial evidence that it's unfair to sandbag with the defendant with at the end of the case? And would bringing this evidence forward at the last minute unduly highlight the evidence? Those were all the issues that are involved
Oh,
in
salty.
the court's exercise
Thank you. That
discretion as
looks
to whether or not
delicious.
it's proper rebuttal testimony. But Mr.
Coffee.
Kelberg tries to make a point which plays fast and loose to the facts as to whether or not these RFLP results are direct rebuttal to Dr. Gerdes, and it is not, for a number of reasons. Number one, Dr. Gerdes testified about item 31, and the board involved in item 31 is a PCR result of a sample collected on June 14th. That's item 31, where he disputes what we call the failure of controls on that particular set of results, and it has to do with the sample collected on June 14th. I would note for the court's edification that item number 30, which was also collected on June 14th, had DQ alpha types that only were consistent with Mr. Simpson and no evidence of any other contributor. So that was not a mixture. Those 30 and 31, those are June 14th. Also presented on the prosecution's case were PCR results as to 303, 304, and 305, the samples that were collected on August 26th. Dr. Gerdes did not comment on the PCR results on 303, 304, and 305, taking the position that as a scientist, he would not even consider those samples because the Bronco, after June 14th, was outside of the chain of custody that he, as a scientist, normally requires for examining the integrity of evidence. So he did not comment on 303, 304, and 305, those PCR results. These RFLP results are on 303, 304, and 305. They are not on 30 and 31. So it doesn't directly rebut that. Nor can they come in and say, well, those are really the same samples, because they were at great pains to have Matheson testify that even though 30 and 31 were supposed to be in the general area of, even though 303 and 304 were supposed to be in the general areas of 30 and 31, they were separate and distinct swatches of separate and distinct bloodstains. And they have to take that position, collected on completely different days under completely different circumstances, that those are separate and distinct pieces of evidence. So the fact of the matter is that these RFLP results are not being offered to rebut Dr. Gerdes' questioning of the scientific controls on item 31, because that is a separate and distinct sample. What they're being offered here is to add additional evidence to the PCR results from the 303, 304, and 305, which were samples that were collected on August 26th. So those are the facts. Secondly, I would point out, in terms of the rebuttal argument, that when this issue was first raised about their failure to pursue these tests in a timely fashion, and in fact, in the whole issue of the Bronco samples, I pointed out to the court exactly what was going on. I stated to the court at the whole discussion, starting, for example, at 27331 of the record, in the argument on, I think it's May 12th, and I had previously indicated to the court on March 29th at page 20966 in the record, and that's where we were having the general discussion of when we re-raised our challenge to DNA evidence under prong 3. I was discussing then under prong 3 that there was a failure of controls on some of the evidence samples collected from the Bronco, and that this was a problem in the people's case. And that what I was fearing here is that they were not going to proceed expeditiously with the RFLP results from the combination because they were going to sandbag us with this. And they could have it done on their direct case, but they were choosing not to because they wanted the best of both worlds. If they got ambiguous results, they wouldn't offer it. And if they got results that they thought supported their claims about 303, 304, and 305, they would suddenly bring this in at the end of the case in a fashion that unduly highlighted it, and I called it sandbagging, and I described exactly the problem from the very beginning. I reiterated that again on May 12th. It was absolutely clear what they were doing. Now, I think on this record, as far as the issue of timeliness is concerned, there can be very little debate. When this court permitted them to combine the samples, it was the understanding of this court, and you said it yourself, when we had our discussion on May 12th about this, that it was our understanding, your understanding, at page 27331 of the record, that when they got permission to combine these samples, they were going to proceed expeditiously with the testing, and it was going to begin immediately, if not sooner. Now, during those colloquies, Mr. Harmon took the position, and it's been the people's position all along, that there are no legal restrictions. Even the restriction that they should put on their case, the evidence they have available to them in their case in chief, and they can't just suddenly save testing for their rebuttal case. They take the position that they are completely unfettered, that we cannot in any way, the court cannot direct them, there are no rules restricting them on when they do the testing, that they are completely free to do it whenever they want. That was their position. That's the position they've taken from the beginning. Now, the fact of the matter is that this court told them and made it clear that once they got permission to combine these samples, and in light of the arguments we were making about fears of sandbagging and everything else, that this testing should begin immediately, if not sooner. When the issue was then raised again, this court indicated to the prosecution on May 12th at page 27340 of the record that we may have here a preclusion by the passage of time. Now, I don't know how much clearer the court could have been that they had to make a real effort to get this process started. And Mr. Sims' testimony is absolutely clear. And these prosecutors knew, everybody knew, that they were dealing with a very small amount of DNA. That was determined as early as March 22nd, that the big period of time that it would take for these RFLP tests to get completed, because it was a small amount of DNA, were the times that it takes once those probes are beginning to, the autoreads are developing when the probes start. That's going to take like maybe 2 weeks per probe. That's where the time is going to take in completing the tests. So the issue is, could Mr. Harmon have said to Mr. Sims, look, the judge has made it crystal clear to us, immediately if not sooner, this RFLP testing ought to be done. We could get precluded by time. This is something that should be done. Get Steve Myers to do it. Get Renee Montgomery to do it. The process of beginning that probing is one that he concedes takes 3 or 4 days overall, and in terms of actual hands-on time is much less. He could have been doing other things while the restriction was done, while the Southern blot was prepared, and these things were going overnight. While the analytical gel was prepared, that is a 3 or 4 day process. He'd prefer that it be done on consecutive days, but he didn't even do it on consecutive days, as the record is clear. They waited from March 22nd, by his own admission now, to April 25th, that's what he said this morning, even to plan the restriction, which is a process that he just conceded takes 2 or 3 hours. Now, the point here, Judge, is that these prosecutors, even being confronted with the fact that they were obviously trying to flout the rules and sandbag us with these results, and even in the face of the fact that the court told them immediately, if not sooner, you could be precluded by time, did not say to Gary Sims, look, they spent, and this record is clear, he spends close to 25 days and 100 hours between March 22nd and coming into court to testify in preparation for testimony, reviewing his notes. He spends a week sitting in his hotel room watching Robin Cotton testify, when on other occasions he had been listening to the witnesses, or he could have been done on videotape. It doesn't take that long to get these probes started, where the major bulk of the time is going to take. And as Mr. Sims conceded, once those probes are beginning to cook for those 2-week periods, he doesn't even deal with it, technicians deal with it. And there's another person in the lab who pitched in on the RFLP and other work, in this case Steve Myers, who could have taken out some short period of time to get this done if they wanted to get this done. But they didn't want to get this done. In spite of the court's clear admonition to them that they could get precluded, they were flouting the clear direction of the court and trying to gain a tactical advantage. The record is crystal clear on this, crystal clear that this would have been available to them if they proceeded in anything close to an expeditious manner. There is a huge gap here between March 22nd and when these probes went on June 15th. It is inexcusable, it is purposeful, there can be no question about it, it is in bad faith, and we don't even need bad faith. It's just a question of whether or not it was available to them. And it is arrogant. It is arrogant. How clear could you have been to them when you said immediately, if not sooner? It was all our clear understanding they were going to proceed with this important evidence expeditiously. They were trying to gain a tactical advantage. That's all there is to it. And Mr. Sims, I concede, is a fine man. He has a lot of work to do. Demands are made for him in preparation of his testimony, but it's on them. They could have said, the court's been clear as to what the timing is, get this done, get somebody else to do it, because it was a very simple process to get those RFLPs going, the 3 or 4 day period that it takes to do the restriction, the analytical gel, and get the probes going. They knew precisely what was going on. Mr. Harmon is experienced in how DNA testing works. Mr. Sims made that data available to him. They'd rather sit around and talk about how the testimony should go or watch television with other witnesses when they could have done it. The record is crystal clear on this, and they basically were figuring, well, Judge Ito didn't rule against us in terms of when we should start the tests at the beginning of the trial. It was a close call we had on that ruling, but he didn't rule against us. And we take the legal position that there are no obligations on us to begin testing at any particular time or to make anything available in our case in chief. And even after Judge Ito told us immediately, if not sooner, it was clear to us that there was a time problem here, we can ignore it because he's not going to do anything about it, despite the clear rules and the clear admonitions and the clear point that they were taking an unfair tactical advantage. That's what they think they can get away with. And that's exactly what the record shows, and it's exactly the game that they're playing. And it is unlawful. It is not directly rebutting testimony. As I've indicated, Mr. Kelberg's arguments are playing fast and loose with the facts. This is not rebutting 31, a sample collected on June 14th in a particular PCR result. This is supplementing the previous PCR results from 303, 304, 305, samples that were taken on a different date, samples that the prosecution witnesses were at pains to say were taken from a different blood stain on that console.
We're repeating ourselves at this point.
Okay. With respect to the law of rebuttal, the prejudice here is clear. This is important evidence in the case, and by proceeding in this fashion, they are trying to unduly highlight this evidence, and it makes it extremely difficult for our witnesses who would have been on direct examination to confront this evidence when they first testified. That's the advantage that they're seeking, and that's the advantage which the law says is improper in terms of proper rebuttal, and this is not even rebuttal. This is really reopening their case. It is absolutely and utterly unjustified. Now, with respect to what this is going to entail, Mr. Kelberg made another argument that is fast and loose with the scientific facts with respect to the numbers and the testimony that would be required from Dr. Ware on mixtures and the peculiar problems presented by mixtures here. And on this point, if with the court's permission, I would like to defer to Mr. Neufeld, since this is his area, to address Mr. Kelberg's point with respect to the statistics. Well, they got two people to
A
do it.
very discrete issue. You've chosen to argue both issues, counsel. Conclude.
But he made both issues. No, I didn't choose to argue it. I'm saying I don't want to argue both issues.
Let's finish this. We've spent almost 2 hours now on this.
The arguments with respect, Mr. Kelberg argued that the RFLP results on 303, 304, and 305 merely serve to corroborate the PCR results on 31, which is a completely different sample at a different time. And it can't be corroborative for a number of reasons. Number one, what we're talking about here is a mixture. And this court has already ruled that you have to have a number for the mixture. And that obviously, creating a number for a mixture is a complicated process, as we've seen. The problem, and the key problem here, is that the jury has numbers about a single source RFLP pattern for Mr. Goldman and Mr. Simpson, which are very, very small numbers, very low frequencies. And they may assume, they would be entitled to assume, that if they just heard, well, there's an RFLP that shows a mixture of a pattern consistent with Mr. Simpson and Mr. Goldman on the 303, 304, 305 combined stain, the argument is the jury would naturally think that those very, very low numbers in the millions or billions, whatever the patterns are the numbers that they should apply to the mixture on 31, which is an entirely different stain anyhow. And we know, even from the calculations of Dr. Weir, which we contest are unduly making that probability a low one, that a mixture is different, and it is far less of a persuasive number. And you have already ruled that it's the law of the case that they have to present those numbers. And that's what Barney rules. They have to present those numbers separately, and it would be plainly prejudicial here on an entirely different sample to let them not present a number on a mixture. Not only that, Dr. Weir's report that we have gotten here, because of some peculiarities in these RFLP results, engages in a completely different method for calculating the mixture, different than even the one that he presented here the last time. And so it seems that it would be contrary to what this court has already ruled with respect to the need to present numbers from mixtures to let them put on an RFLP result for a mixture and let the jury speculate about what that could possibly mean. It just violates all the court's previous orders in this case. Finally, I think it's clear from the testimony of Mr. Sims he's not qualified to present these numbers with respect to mixtures anyhow. He doesn't have sufficient expertise in statistics, particularly on a method for calculating a mixture which has never been published, which Dr. Weir was essentially presenting for the first time in this court himself. When Mr. Sims' only background in this essentially is taking a few day courses a while ago from Dr. Weir, which couldn't have even addressed the method that Dr. Weir testified to and presented in this case. So for all these reasons, what we're facing here is that if you permit this, what we think is not rebuttal testimony, reopening the case, despite all the warnings this court gave them that they were at peril if they didn't get this done, to be precluded. If you permit it, Gary Sims would have to testify about the RFLP, Dr. Weir would have to testify about the mixture numbers, and we're going to have to call Dr. Shields as a rebuttal witness on all of this. So that's what we're facing. It's unduly extending this case, and it wasn't necessary in the first place, and it was only done to gain an unfair tactical advantage.
All right. May I respond briefly, Your Honor?
I'm interested in just two things.
All right.
I'm interested in the physical proximity of 31 and 303, 304, 305, and I'm interested in an explanation for the delay between March 22nd and April 25th. I'm only interested in those two things.
All right. Mr. Clark has been kind enough to do Mr. Goldberg has been kind enough to do a drawing. Unfortunately, I also used it to write a note or two to myself. But let me hold up for the court's observation. The note is Matheson took swatches from the area immediately contiguous to the 30 and 31 stains, and it looks like the concentric circles one might see on the stump of a tree after it's been cut. And the court can see the proximity. I think the court can see from the distance. If you'd like, I can bring it up for you to...
No, I can see. Thank you.
The proximity, and obviously that goes to the relevancy of using 303, 304, and 305 to corroborate the accuracy of the 31. It's not an issue of when the stains are taken. Obviously, the people's position is those stains were deposited at the same time, June 12, 1994, in the late evening hours. And so the real question, and by the way, Mr. Goldberg hands me from a property report that bears the contiguous numbering scheme with 000685 DR94-08-17431 under the last item listed 6 cloth swatches, 5 used to collect additional stain from the same location of item 30, right side of, looks to me to be center console, 1 swatch used to collect a control area adjacent to the stain. I think is what Mr. Goldberg would like me to apprise the court of if the court was not aware of that. The point is that the contiguous contiguous relationship between the stains 30 and 31 and 303, 304, 305 is really the issue on the theory that they were deposited clearly at the same time. I don't think anybody can really argue with good faith that an RFLP result cannot corroborate a PCR result. And so if the court finds that, in fact, the area is the same general area for these stains, and Mr. Goldberg then points to the next item from the same report, next page, saying, looks to be 6 cloth swatches, 5 used to collect additional stain from the same location as item 31, right rear top of the center console, and 1 swatch used to collect control area adjacent to the stain. So that should take care of identifying where 303, 304, 305 come in relationship to 30 and 31. So that makes it clearly relevant. And I hope that answers the court's question, because clearly circumstantial evidence, which corroborates the evidence received in the people's case in chief from the PCR results on 31, is rebuttal evidence. And I must point out to the court, Dr. Gerdes took the stand in August. According to the notes from Mr. Sims, Dr. Blake saw the D4 autorad on July 20th. That's before, I believe, that's the third probe? Second probe. So he at least knows we've got a 2-probe result at that point, and certainly his interest must be piqued. I'm assuming Dr. Blake is in contact with Dr. Gerdes in preparation for the defense case, so Dr. Gerdes has to at least be aware of this. Dr. Gerdes attacks all PCR. Unlike what Mr. Scheck says, in fact, Dr. Gerdes does inferentially attack the results on 303, 304, and 305 because he says PCR forensic out for inclusion, exclusion, and that's going to take care of all of our PCR results, if you believe Dr. Gerdes' opinion. So with respect to the first question the court has, that is the direct response. With respect to the delay, Your Honor, I know the world thinks this is the only case in California, the only murder case, the only rape case, the only case where DNA evidence is involved. I think the world has seen one thing. Gary Sims is a meticulous craftsman of his trade. And I must say it's a bit disingenuous to have the defense attack Dennis Fung as a bumbling fool and then criticize Gary Sims for being a craftsman in his trade. And I must say, Your Honor, if every judge said to the prosecution, I want this case put to the priority number one and everything done ASAP on this case, how can any laboratory figure out which priority really comes first? The law requires we use judgment and reason and common sense. And I think from the record that's been laid out here today and yesterday evening, and an interesting record it is to learn how Mr. Sims spent his spring and early summer, it is clear that the prosecution had a scientist of the first order who wanted to be certain that he was doing things carefully so that the same kinds of attacks made on others would not be an attack made on him. And I must say, Mr. Scheck's suggestion that other people could come in and do this, I doubt there are too many folks in the scientific community or in our office who would want to rush in and volunteer to get involved in this case. And as one who was asked to come in kind of at the last moment, hindsight being 20/20, when the call came, I maybe should have reconsidered. I have a feeling that that gentleman up at the DOJ lab that's been mentioned as a possible person to have taken over for Mr. Sims, probably saying, man, thank God I wasn't the one asked to do this. Scientifically, it makes sense, of course, to have one person try and control the sequence of tests so that you can have the chain of custody and you can have the continuity of presentation. And that's what Mr. Sims provides. I must speak in response to Mr. Scheck's comment about the prosecution. We wanted the best of both worlds. Boy, if we got an ambiguous RFLP result, hey, we bury it. We don't bury it. We Brady it. We bring it to the court's attention. We bring it to the defense's attention. And they're going to say that that result corroborates Dr. Gerdy's opinion that the 1.3 allele on 31 is an artifact. We want scientifically reliable, valid results to offer. Mr. Sims is that kind of scientist. He took his time. He had other responsibilities. I don't believe this court, in hindsight, can say that he was negligent in how he went about his business. He was examined at length as a witness here. For the court to say he should not have properly prepared or should not have listened to other witnesses who testify, all the experts in this case are listening to the experts on the other side or on their own side who testify in related areas, because it could be a matter for which they will have to give testimony or be subject to cross-examination. Is that unreasonable?
Let's go back to my original question then.
Okay.
Your explanation for the delay between March 22nd and April 25th.
I'm sorry, March 22nd and April
25th.
I think Mr. Sims has laid it out. He wanted to make sure in the way he does business that, number one, he had the human DNA, and he did some additional work to make sure he had that, and to be sure that he could conduct the tests in the manner that he feels is scientifically necessary, and without knowing for certain when he's going to have that continuous period of time necessary to do these tests in sequence. If he gets tied in to begin with, and something comes up to take him away, he's not going to be able to do one thing or the other. He exercised his judgment, Your Honor. If the court feels he made a mistake in exercising his judgment, do we keep this jury from learning the truth? Do we keep this jury from learning something that corroborates Mr. Sims' original testimony and shows that Dr. Gerdy's is simply wrong? This is not bad faith. This is just going through the process of doing his work in a careful, meticulous manner and having time go by. You know, maybe what we should have done when the court said, is it time for you to rest? We should have said, no, we can't rest. We got to wait for these probes to be done. You know, the defense says they can't rest. This is unusual circumstances, at least in my experience, Your Honor, when one side doesn't rest waiting for something to come in. I mean, maybe that's what we should have done. Hindsight being 20/20. That's not what we did. The point, though, is there's no reason for us not to want to put on this evidence if it is available. But we want to put it on when we are certain that it is reliable and valid. And I ask this court to recognize that in this case, time estimates by all sides have proved to be very, very short-sighted estimates. And to hold Mr. Sims and the prosecution at this time because of what the court may perceive as an unnecessary one-month delay between the period in March and the period in April, I think is to penalize us at a time when we cannot penalize really anyone else for estimates that have proved to be less than accurate. I don't think the court can see Mr. Sims as someone who intentionally avoided doing what should be done to get results. And that is, I believe, what the court would have to find. bad faith by the prosecution, trying to gain an advantage. And I think this court understands from Mr. Sims that he's not the kind of man who's going to let any prosecutor tell him how he should do his business in order to gain a tactical advantage. He is the scientist. He is the one who believes this is the mechanism he must follow to get a reliable and valid result. This is true rebuttal evidence, Your Honor. If the court has any other questions, I'll be glad to answer them. Otherwise, I'll submit the matter.
Thank you.
Do you have a brief response?
5 minutes.
Mr. Kelberg's argument is completely circular. He says since it's obvious that 30 and 31 were deposited on the same day, June 12th, as 303, 304, and 305, then if we put on evidence about 303, 304, and 305, it rebuts Dr. Gertie's criticism of 31. Well, that's not the record in this case. And it's plain from the testimony of other witnesses that we're contending, or the jury is free to believe, that all those bloodstains were not necessarily there on June 12th. That's the point. Secondly, they can read from police reports all they want, but I commend the court's attention to 25187 of the record, where Greg Matheson's begins to discuss his collection of 303, 304, and 305. And as I indicated, he is at great pains to point out that he was swatching in the vicinity of 30 and 31, but he was distinctly taking a different bloodstain that he had actually seen, he claims, a lighter area which might have represented previous swatchings, and he was taking a new sample. So, again, it is a circular argument, and it is not directly rebutting. This is evidence about 303, 304, and 305, which Dr. Gertie's did not address. He was addressing 31. And as I point out again, on 30, there's no evidence of even a mixture. His argument about no one else should be asked to do anything in this case, the record is clear. Steve Myers assisted in other RFLPs in this case, and this was really nothing more than a ministerial matter to begin the restrictions and the analytical gel, and it could have been done. I would point out to the court that the record is that on March 22nd, they knew how much DNA and they knew how long it would take. He only began planning on April 25th. The restriction, which is a process he would take 2 or 3 hours, and he didn't actually begin it until June 7th. So I would submit that the real delay here is between March 22nd and June 7th. Finally, the prosecution is very conveniently putting it on Gary Sims. I think the record's clear. It's not Gary Sims. The activities of Mr. Sims between March 22nd and the time April 25th or June 7th were primarily taken up with preparation sessions for testimony in this case. When Mr. Kelberg says, who sets priorities with reason and judgment and common sense? It's them. They could have said to Gary Sims, Mr. Sims, it only takes a few hours and a 3-day or at most a 4-day process to begin getting those probes cooking, which is going to take the longest period of time developing them. The judge said immediately, if not sooner. The judge said we could get precluded because of time. The record is clear. During this period between March 22nd and April 25th or June 7th, as we would contend, they could have told him to do that. They could have suggested he gave no scientific reasons why that couldn't be done. It's not a question of Gary Sims' scientific judgment and trying to be careful. That's all a lot of nonsense. Steve Myers could have done it, but that's not even the point. They had the obligation. They had the obligation to say, the judge has made us clear that we are in danger if we don't make a good faith effort to get this evidence there, or an effort. The standard is not even good faith as far as the rebuttal issue is concerned. We have a problem. The defense has made it clear what the problem is. The judge has told us in no uncertain terms immediately, if not sooner, we could get precluded because of time. Just start that 3 or 4 day process to get the RFLP results going. That's what the prosecution could have requested of the scientist, and he didn't get up on the witness stand and say there was a scientific reason he couldn't have done it. It's on them, not Gary Sims.
All right, thank you, counsel. All right, I want to review 2 items from Dr. Gertie's testimony, and I want to review, before I rule, the exhibits that discussed items 31 and 303, 304, and 305. So I'll have to have Mrs. Robertson pull those out. Mr. Kelberg, would you give Ms. Robertson a list of the exhibits, the photo exhibits? All right. As to the 1054.7 hearing that the court conducted with regard, and Brady hearing that the court conducted with regard to Dr. DeForest, where's Mr. Neufeld? Chose to absent himself. Well, Mr. Scheck, would you tell him that the result of the hearing this morning was that the pages that the court had concerns that were potentially Brady material were in fact turned over in a previous discovery matter, so the issue was moot.
Well, Mr. Hockman, it strikes me before he left and said that the issue had to do with the wet transfer stain of Nicole Brown Simpson's blood on the other sock that went through the other side. And I want to point out that that's a finding not just of Peter DeForest, but Mr. Simpson. So I understand, if I take it, this is the July 17th materials. Are there pictures associated with that?
No. But there were notations, that's what caused me concern about whether or not it was Brady materials, but it turns out that that had been, unbeknownst to me, had been previously turned over to you.
Okay.
All right, so I wasted all of my time reading those materials.
Well, if it had been put together in a fashion and a form, it would have been easier.
So there was another 2 hours of my time.
Your Honor, may I be excused so we can go upstairs, get the exhibit numbers, and
Yes.
give them to your clerk?
All right, thank you. All right, on, let me see. All right, Ms. Clark, do you have your next witness available?
Yes.
All right, where do you intend on going after Mr. Rubin?
After Mr. Rubin, then Gary Sims.
How long do you anticipate will be with Mr. Rubin?
5 minutes. 25.5 minutes.
All right. Mr. Blazer, any guess?
No, but I do have a limited motion to make with respect to Mr. Rubin, briefly.
All right, we'll hear it.
I would ask that he be limited, in terms of looking at pictures or testifying about pictures, that he be limited to what has been presented and identified in court and not testify about pictures that aren't in court.
Ms. Clark? I'm sorry, Mr. Darden, any comment on that?
No, we intend to show him anything we can lay the appropriate foundation for, Judge.
Are there any other materials that have not been presented in court or that defense counsel has not had access to that you intend on using?
I don't believe so.
All right, I see we have counsel from NBC with regards to the SDTs present in court.
I would ask that Mr. Rubin be instructed to not testify about things that he's not shown.
What's the, it would be an incompetent opinion if he were to testify and give an opinion on items he has not seen or examined, wouldn't you say?
No, that item that the jury has been presented with. He's seen other items. I don't want him blurbing out things about things that haven't been introduced. That's my only concern. Well, I'm
All
not
right,
sure
what's the
Mr. Rubin
status, what's the status of our, Mr. Yokelson, what's the status of your conversations with NBC?
Your Honor, Ms. Edgerton is here from NBC. I'd ask her to step forward. She could step forward to represent NBC's position. However, with respect to the declarations that we referred to yesterday, apparently Ms. Edgerton has been unable to secure any modification. However,
I'm sorry. All right,
she's of the opinion that I
hold on.
joined.
All right, the record should reflect now the presence of the defendant, Mr. Simpson. We also have present counsel Ann Edgerton representing NBC. Good morning, counsel.
Good morning, Your Honor. I wanted to summarize very briefly for the court the history of these 10 subpoenas, now 11. We received another one late yesterday, which I'll come to in a minute.
All right, it's noted in your letter to the court.
Yes, I know, Your Honor, but what we have on the record as of late yesterday afternoon is a statement by Ms. Clark that NBC has been, I think her phrase was, totally uncooperative in responding to these subpoenas. And therefore, I would like an opportunity very briefly to summarize for the court what the history of this has been. We have received 10 separate subpoenas over 14 months. In response, we have responded to each and every one of those subpoenas. We have produced 19 separate videotapes, which constitutes about 3 Beacons boxes full of material. In addition to the videotapes, we have produced at least eight custodian of records declarations. In order to produce those videotapes, which were first requested on VHS and then later on 3/4-inch tape, we were asked by the district attorney's office to produce them on a very expedited basis. As a consequence, we had videotape engineers working nights, and we had videotape engineers working weekends. I personally have spent more than 50 hours responding to these subpoenas. There are countless others at NBC, videotape engineers, clerical staff, other lawyers, many in the sports division who have spent tens and tens, if not hundreds of hours complying with the many, many requests for footage that we have received from the prosecution in this case. So when Ms. Clark represents to this court and to the public that we have not been cooperative, I can only conclude, Your Honor, that she has not yet had an opportunity to talk with her colleagues in the district attorney's office with whom I have been in almost constant contact over the last year, including Mr. Yokelson, Patty Jo Fairbanks, Ken Lynch, and Mr. Hodgman himself, who told me as recently as last Tuesday, in essence, that he appreciated our many efforts to date. All of these subpoenas may well be invalid. They are issued by a California court for the appearance of a witness who works and lives in New York and for footage located in New York. As I'm sure the court is well aware, there are specific provisions in the California Penal Code in 1334.3 for securing the attendance of witnesses in foreign jurisdictions. The district attorney's office, for reasons that I am not privy to, Your Honor, has made no effort to comply with any of those provisions here. We, I believe, respectfully would have been well within our rights to decline to respond to the subpoenas, but we have not done that. We have responded promptly. We have knocked ourselves out to get them 3 boxes full of material. And the only thing that we have respectfully declined to do is to fly a witness voluntarily in response to an essentially invalid subpoena, to fly a witness 6,000 miles to testify that a piece of footage of an NFL game is what it appears to be, a piece of footage of an NFL game. Until yesterday at about 4:30, when Ms. Clark mentioned the January 1992 game, we did not even know which specific footage in those 19 lengthy tapes in 3 Beacons boxes full we were being requested to produce a witness to authenticate. And the reason that there is not a person who is the person that we could bring out here to do that is because of the way these copies were made. Because the prosecution wanted them on a very expedited basis, and because we had people working literally around the clock in New York in videotape edit rooms making these dubs, there were a variety of people who worked on the dubs, many, many different videotape engineers working night shifts and so on. They were supervised by different managers of the videotape library. So my concern, which I've expressed many times to Mr. Yokelson, with whom I've had a very good relationship all these many months, and to Mr. Hodgman last week, is that my concern is that if we were to fly a witness out here, that witness might not be able to say, that witness would not be able to say, I made these copies myself. Under NBC's contracts with unions and guilds, that work is done by represented employees. They may be supervised by others. So what we have repeatedly said is we don't understand, quite frankly, why the prosecution couldn't simply say to the defense, these are the clips we want to get in. These are NFL games at which Mr. Simpson himself was present. No one can really dispute that these little clips are what they appear to be, clips of games at which Mr. Simpson was present. So I have a motion to quash that I have prepared. We're not going to file it, Your Honor. If the court wants us to bring a witness 6,000 miles to testify to this simple foundational fact, we will do that. As I say, there has been no compliance with 1334.3. Why that is, I don't know. We get subpoenas every day, sometimes 3 or 4 a day, from lots and lots of people who all think their case, federal or state or civil or criminal, is as important as this one. We try to respond to all of those. Most of those people follow the rules. Now, why some of the rules aren't being followed here, I don't know. But the bottom line is we certainly don't want to be blamed for the prosecution's not going through the Uniform Act. And if the court says to me, you want us to fly someone out here, that may mean we have to redub the footage, because I'm not sure we can identify the person who in the middle of a night on a Tuesday last June made that little piece of tape that I understand the prosecution now seeks to introduce. We will put that person on a plane and we'll bring him out here.
Mr. Yokelson.
Your Honor, we're spending much too much time on something that could have been handled in a perfunctory manner. Yes, NBC has provided videotapes whenever we've asked for them. What they have not provided us with is the guarantee of a live witness if necessary, or a custodian's declaration of records, which was not received until yesterday. We now have a custodian's declaration of records, and we are prepared to go forward on that. With respect to the specific tapes that were going to be introduced in court, at Ms. Edgerton's request a week and a half ago, I sent her a chart detailing specifically what segments we were using, and I asked her to try to make efforts to ascertain who dubbed these and who would be the live witness. Those results are still not forthcoming. Regardless of any of this, the fact of the matter is we are seeking to introduce footage at this time from one football game played on January 5th, 1992. Now, I agree with counsel that this is a matter that parties could easily stipulate to, but frankly, counsel from NBC is not trying this case. the lawyers here are trying this case. And we have asked the defense to consider a stipulation. That has not been forthcoming, and frankly, we can't force them to accept a stipulation. We are going to ask the court today to take notice of the declaration of records that has been filed. We can explain this. It covers the segment of tape that was played in court yesterday, and we believe that this will suffice, and this will settle the matter.
What is this? Is this a new declaration from the one that was submitted yesterday?
It's the same declaration, but I believe we can point out to the court that the videotape that was offered in court is videotape that came as a result of this declaration. That declaration refers to a pre- and post-game show, which they were unable to locate. However, the declaration also states that the remainder of the tape was provided by NBC for the game and the halftime shows. The segment of tape that we are offering is a brief segment that came at the end of the halftime show and the beginning of the third quarter, and it came from the 3/4-inch videotapes that NBC provided. In fact, I have them here in court. There does remain a matter of a second subpoena, which we can take up in a moment, but let's cover this. We believe that Evidence Code Section 1560 has been fulfilled and that the foundation has been laid with respect to this one piece of video.
All right, I thought the declaration from Mr. Laplace yesterday indicated that he could not vouch for that particular videotape. Did I misread that?
Your Honor, Mr. Laplace's, he did 6 different declarations because we received the subpoenas which were sort of oddly framed. Some of them would call for, one would call for the halftime show, another would call for the pregame game and postgame. In another set of subpoenas for another date, one would call for the pregame and one would call for the game. Anyway, so we tried to frame the language of the declarations to respond to each subpoena. The one that is at issue here, as Mr. Yokelson said, called for the game, the pregame and the postgame, not including halftime. What we were unable to locate was the pregame and postgame, even though we had a retired person even check at his home for tapes. That is not, as I understand it, what the prosecution seeks to introduce. So the bottom line is that we have authenticated all footage we produced. Needless to say, something we could not locate and did not produce, we wouldn't presume to authenticate. So the language the court may have been looking at yesterday, which is at lines 17 and 18 of that declaration, refers only to the pregame and postgame footage, which, again, I understand is not now at issue.
And that is not what we were offering.
So paragraph 2, Your Honor, which...
I'm sorry, which affidavit are you
well, the
referring
problem
to?
is they're all dated July 5, so it's a little hard to tell, but it's the one, if you look at line 11, it's the one that says, that refers to the Chiefs and Bills, played on January 5, 1992. And it says the videotapes that were produced contain a true copy of the
All right.
broadcast footage of the game. It was prepared by NBC personnel in the ordinary course of business at or near the date, et cetera.
All right, any other comment, Mr. Glazier?
Yes, Your Honor, as I understand it, and I think it's important that the papers that we got from NBC indicate that the first subpoena for these football games was July 11th of 1994. I think that's relevant to the issue of whether they had adequate opportunity to prepare this issue. Nonetheless, I think what the court's being asked to do is to take some sort of notice of what NBC says is a legally invalid subpoena with a declaration that says we can't provide you everything that you subpoenaed. We don't know where the rest of it is. We object to that. It's the very reason why a custodian should be here to clarify that. We're not prepared to stipulate to anything, and we think this is an invalid subpoena, an affidavit that tells them I can't give you what you asked for, and we object to it.
Mr. Yokelson, any response?
Your Honor, if NBC, we believe that the provisions of Evidence Code Section 1560 have been complied with. If counsel is willing at this time to provide a custodian of records to fly out here, we'll pay for it and we'll deal with it.
All right.
But we want to use the evidence now, and we're indicating that this is our good faith representation that we can establish a foundation for this tape.
All right. Is the matter submitted?
Yes, except for there remains a second outstanding subpoena with respect to testimony from the witness yesterday, Deborah Gadara.
We received yesterday, shortly before 5 o'clock, Your Honor, an 11th subpoena from the District Attorney's Office. This one says that we are to provide a live witness tomorrow morning at 9 o'clock in this court and to bring with that witness another 5 or 6 of the big 3/4-inch tapes of now a 1993 game. Because of what we've been through on this, Your Honor, frankly, I would like to just seek the court's guidance. If I don't want to file a motion to quash. There are the same problems with this subpoena as with all the others, the noncompliance with 1330 and 1334.3. But frankly, Your Honor, I have spent hours and hours and hours. I want to be done with this. If the court wants us to bring a live witness tomorrow for that, we'll try to do that.
Your Honor, for that, we don't need a live witness. We can do that later. If we could simply have that tape, even in a VHS format, we'll accept it, along with an appropriate custodian's record that will meet meet the requirements of Evidence Code Section 1560 and the foundation that's been laid in the form of the testimony of Deborah Gadara.
All right,
We can do that, Your Honor. I'm just not sure we can do it by 9 o'clock tomorrow morning. Typically, under Evidence Code 1560, we get 5 days.
I understand.
We'll do our best, as always. Your
All
Honor.
right, I'm going to direct you to make your best efforts then to provide the tape and declaration of a custodian of records by the close of business tomorrow. All right, thank you. I'm sure you can get it FedEx today.
On the, now on this January 92 game, we are to bring a witness tomorrow morning?
As to the January 92 game, I'm going to find, on the basis of the explanation given to me, that the declaration that is page 13 of 16 of your letter to the court dated September 11 is sufficient for the purposes of the California Evidence Code, so the objection will be overruled.
Thank you, Your Honor.
All right, Mr. Blazer.
You know, as to this next videotape, we have not been provided with that. We have not been provided with 3 Beacons boxes either. But the one that we're talking about now is central to Mr. Rubin's testimony, and I cannot cross-examine him on the Gadara picture until I see the videotape. If you'll notice, the Gadara picture does not show a lot of detail. I can't cross-examine him on that without seeing this videotape.
And, Your Honor, we haven't seen it either, and we're attempting to get it, and when we get it, we'll evaluate the evidence. But the fact of the matter is, we don't have
Well,
it either.
given the offer that it's going to take 20 minutes to direct examine Mr. Rubin, Mr. Rubin may be on and over before any of this stuff shows up.
Well, if that's the case, we will still move to present the videotape and let the jury evaluate it for themselves.
Well, that'll be something we'll take up later.
Well, Your Honor, tactically, I can't cross him on something when there's other evidence out there that I don't know what's in it. I have certain questions I want to ask him about that picture. I can't do it this way.
All right, Ms. Edgerton, I think your duties are done. Thank you. Mrs. Robertson, may I see the board again from yesterday? And Mr. Hayden will take up the Pitchess matter as soon as we conclude this. Excuse me, counsel? All right, the Gadara photographs are what appear to be brown gloves, and Mr. Simpson appears to be adjusting microphone control. All right, thank you.
I would be happy to make an in-camera showing at sidebar as to why I can't cross without that video.
All right, I don't think that's necessary at this point. We may have to adjourn the cross-examination at that point, as to Mr. Rubin. All right, as to the Pitchess matter, we'll conclude this, and then we'll bring the jury down. I'm sorry? All right, Mr. Scheck, you filed a supplemental memorandum of points and authorities.
It really is, frankly, nothing more than the case that I said there was a Pennsylvania case from the Supreme Court. It was Pennsylvania versus Ritchie. And I would commend to the court's attention that these are cases directly on point with respect to statutory privileges, and I'm sure the court is familiar with other related case law concerning informants' privileges, but the point is simply that our Brady rights trump any absolute prohibition here. And we think there are a number of different ways that the court can pursue these records. Obviously, it's futile to pursue a Pitchess motion that limits us to something that goes back, limits us to 5 years, when the material that arose in the course of the investigation in this case by Internal Affairs indicates that what we're all interested in is something that's over 5 years old. And I think the Constitution and due process requires that these records be ordered, turned over to the court for its inspection and possibly turning over to the defense. And therefore, the statutory restrictions of Pitchess have to be overruled.
All right. Any other comment?
Thank you, Your Honor. The statute speaks for itself. The requested materials by the defense in this case have no bearing whatsoever to the issues in this case. My client hasn't worked with Mark Furman since 1989. There's no showing he had anything to do with anything that happened at Bundy or Rockingham. As counsel has still not addressed 1047, and even if one were to expansively view 1047 of the evidence code, you still get to the situation where my client wasn't there. He has absolutely no connection whatsoever. Counsel submitted a hypothetical and a footnote in the brief that he submitted. That hypothetical has no bearing whatsoever to the facts of this case. There's not even a suggestion that my client had anything to do with anything that happened on June 12th of 1994. I would also note that in the defense's purported search for the truth, they haven't exactly engaged in a rush for discovery. The information related to this matter was known to them as early as possibly February, certainly as early as April. They've sat on it. They have not attempted to get arrest reports and transcripts, which they are seeking from my client's personnel file. If there are any such materials like that in my client's personnel file, Your Honor, they have to show first under pitches that they have made a good faith effort to find those materials. They haven't. They certainly haven't given us anything in their declaration to show that they have made a good faith effort to find any of these materials. The whole essence of the pitches statute, Your Honor, is a balancing. It's a balancing of certain constitutional rights. The defendant's constitutional right of confrontation and my client's California constitutionally based right to privacy. And in this particular case, before they can invade my client's personnel file, they have to show there's a necessity for it. And they haven't done that. They have not met the requirements of the statute, and they should be denied access to the file. Thank you.
Thank you.
As to the relevancy of this case, I think it's clear that this officer, in the course of an investigation for Brady material in this case, indicated that he burned a diary that contained information about misconduct of Detective Furman because he knew it was being sought. That this officer, with respect to the swastika incident and with respect to this incident where he could, if we got the records, help us prove that Detective Furman had falsified evidence and asked a police report and asked this officer or got this officer to conform his testimony to prove the code of silence. I think it's all potentially highly relevant, and there might have been more in that diary. We think that this officer, in the answers he gave us, in light of what we found on the McKinney tapes, was not telling us the truth. And we had we did not know, and we still don't know, whether the internal affairs reports that the court has reviewed in camera contain anything about this diary and this information. So we think it's relevant, and we still think that it's extraordinary that the legislature has this statute. Here's Mark Furman in the Furman tapes bragging about all the different internal affairs investigations that he has been able to beat in terms of his own misconduct. And when we make a pitches motion for Furman and we make other related pitches motions, not one thing came out. The only reason we even became clear that Detective Purdy had relevant information as to Furman's racial attitudes, perhaps, dealing with the swastika incident and other misconducts in terms of fabricating evidence, is because of the statements that Detective Purdy himself made to a district attorney in this case who Ms. Clark told to get out of her office. And only because we continued to pursue that, and in light of the new evidence in the McKinney tapes and an additional interview with Detective Purdy and others, are we now on the trail of something that we think will be additional exculpatory evidence. And if Internal Affairs interviewed him in relation to those materials in this case, how can they rely upon a statute saying that we're not entitled to see what files Internal Affairs might have reviewed or ought to have reviewed when they interviewed Purdy, in this case within the 5-year period, just because it relates to something 5 years back? I think that's nuts. But besides that, we have the Constitution to rely upon, and that's where we place our faith.
All right, thank you, counsel. All right, the request under pitches for discovery of the personnel file of Detective Purdy will be denied for the following reasons. One, the issue goes to a collateral matter, which is the credibility of Detective Furman. The conduct and contact between Detective Purdy and Detective Furman dates back to 1989. It is unlikely that their contact would lead to exculpatory evidence in this particular case. Also, the file that has been suggested here, that information is a matter of public record. In the records of the court, it is accessible to counsel. Also, the court is restricted by Evidence Code Section 1047 from going further on this. I agree with you, Mr. Scheck, that that appears to be in conflict with certain rulings of the United States Supreme Court, and I would encourage you to take a writ on the matter. All right.
I realize your 8:30 calendar is overly burdened, so to save you some time, I've written a letter that I'll have copies made of concerning our request for relief concerning further test impressions of Ronald Goldman's genes without an opportunity
I know
for...
Mr. Goldberg's here. I thought we were going to try to discuss this today at 8:30.
Well, to save you time, I have written a letter, and you can read it, and then you can ask him to address it. I just don't want anything to happen before you have an opportunity to deal with it.
All right.
I'm making a copy of it right now.
All right. We will take a recess for 15 at this point, and I'll see counsel in chambers with a court reporter. Right now. All right, back on the record in the Simpson matter, the defendant is again present before the court with counsel. People are represented, jury is not present. The court has had an in-camera hearing with defense counsel concerning the ability to go forward with cross-examination of the people's next proposed witness, Mr. Rubin. And Mr. Darden. And is Mr. Yokelson gone already?
Yes.
All right, on the basis of that offer, my inclination at this point is to require Mr. Blazier to go forward with the cross-examination of Mr. Rubin. However, he may reserve cross-examination as to one or two of the items pending further revelations and discovery, which will require Mr. Rubin, unfortunately, probably to have to return one more time in the next week to 10 days.
Mr. Blazier has Mr. Rubin's home number. All right. Mr. Rubin says he is amenable.
All right, let's proceed.
May I be here, Jim?
As to what?
A couple of motions, a couple of things that took place.
Motions be at 6 o'clock.
Okay. One thing, Your Honor, we are very concerned about what took place back in chambers, and we need an immediate conference with Your Honor. We've talked to Mr. Dershowitz, and we have a perspective that we want to bring to Your Honor's attention. I want to give Your Honor a heads up regarding that, so we need to talk to you right now on that matter. We think it's very, very serious.
You be heard?
Proceed now. With regard to the juror problem, Your Honor. I can address it? All right. Your Honor, in chambers during the last break, one of the jurors who shall remain nameless has a potential problem and brought that to Your Honor's attention with regard to, shall I proceed? With regard to some rental property that she's having. And I understand she
I
wanted
think
to
you
go...
can be a little more oblique in how you discuss it. I
Yes.
understand what we're talking
All
about.
right, you understand, all right. And the court's offer to this juror, we find totally unacceptable to the point that it would be, I think, would have a tremendously adverse effect if that is done. We think it's unprecedented. We took the step of calling Mr. Dershowitz and our other appellate lawyers. They feel so strongly they want to take a writ on it right away.
Take a writ?
We will do that. We will do that. I want to let you know we do that. But I think I should try to talk you out of this process, because what it does, it will taint that particular juror. The rest of the jurors aren't getting that benefit, and those are public funds. And I don't think we can do that. It's over and above someone's salary, and we don't think it's appropriate. And I think I should bring it to you in the strongest possible terms. We feel really strongly about this. Furthermore, this jury will be even more beholden to Your Honor from a standpoint of, not that you give her any cues or clues or whatever, but I think it would be...
You realize there's precedence for this.
No, I don't. I don't think there's precedence for that particular thing, for what's happening in this case. I don't
Take
think
the
so.
writ, counsel.
All right, we will take the writ, Your Honor, but we'd like to be heard further because we think this is unfair to the other jurors, it's unfair to this particular lady, and it's just, I think that it sends a message that's just, it's hard to express. And so I wanted to at least indicate to the court how strongly we felt about this, and I'd like for you to reconsider this, because I think it's going to be a real dangerous precedent to do this when we're not doing this for other jurors, but more importantly, what it says about the system. To pay a juror basically above and beyond that, I think is inappropriate.
All right.
All right, so I think will you entertain further discussion from us?
Well, I've noted your objection.
All right, okay, well, very good. Hope that's it. The other thing is, and the other motion I can bring, we have a motion regarding sequestration of the jurors, and you want to hear that at the end of the day?
6 o'clock.
All right, and we have a motion regarding scope of the rebuttal, which the balance of the
We'll
scope.
take care of that after we finish with Mr. Rubin.
All right, all right. And then we may have some further remarks regarding this juror problem at that time the court will allow us.
All right, style the jury, please.
I need to get a video monitor into the courtroom.
A video monitor? For what purpose?
Clarity. Videotape of Mr. Rubin describe some of the...
Is there a reason we didn't do that during all this downtime?
Yes, I forgot to bring it to your attention and ask your permission.
Is it on its way?
It's right outside the door.
Bring it in. budget include WD-40? The indication by Mr. Darden was that he felt that this monitor had greater clarity.
Can we preview it first? We haven't seen this.
I think this is the same thing that we looked at yesterday.
Well, it has different quality. It's not the same thing.
And this is just another feed off of Mr. Darden. This is just another feed. In other words, you're just directing the same feed to this particular monitor. Which video? The Boomer Esiason video? Which video?
The one we saw yesterday, the Versailles video, the 46 magnitude video.
All right.
Bringing in special equipment because what we've been using for 8 months is not adequate. Is that my understanding?
Well, Mr. Rubin is going to be pointing to stitching and other very, very small items and details on the glove, and that's why we brought a monitor, for clarity.
All right, let's have the, I'll have this played for Mr. Blazier and counsel so they can see if there's any difference on how it's displayed on the direct view monitor. All right, if we're going to use this, Mr. Darden, you're going to have to use the central podium. If you're going to use this, you're going to need to use the central podium. All right, Mr. Fairlow, just leave it there. All right, would you play for Mr. Blazier, please, the video on the new monitor?
Yes, sir.
All right, let's turn the monitor around so we can all see. All right, 90 more degrees. 90. Stand over next to Mr. Darden. All right, so Mr. Harris, this is so Mr. Simpson can see. Swing it around some more. Thank you.
The additional feed is causing us to lose a little too much signal, so I don't think we're going to end up using this. It's just not, it's not giving sort of the image quality that we hoped for.
All right, break it down. All right, Deputy McNair, let's have the jury, please. All right, let the record reflect that we've been rejoined by all the members of our jury panel. Good morning, ladies and gentlemen. All right, people may call the next witness.
Richard Rubin, Your Honor.
All right, Richard Rubin recalled. Mrs. Robertson.
Richard Rubin, R-I-C-H-A-R-D, R-U-B-I-N.
Mr. Darden.
Thank you, Your Honor. Good morning. Mr. Rubin, you testified before this jury on June 21st. That was the last time. Is that correct?
That's correct.
Okay. And you visited me in my office last week, or rather the 30th or 31st of August?
August 31st.
And prior to that date, had you been sent some videotape and or photographs by a member of my office?
Yes, I did receive some.
Was that both videotapes and photographs?
Yes.
And what was shown in those photographs?
There were various still photos and videos of a group of NFL football games where Mr. Simpson was announcing.
And you weren't present in the courtroom yesterday afternoon, is that correct?
I was not.
Okay. But did you watch on television the photographs and video tape that was displayed to the jury?
I saw some of it.
Okay. Did those videotapes and photographs appear to be videotapes and photographs that you have seen before?
Yes, they are.
And having had copies of those same videotapes and photographs, did you have an opportunity to study them carefully?
Yes, I did.
Okay. And you and I talked about your observations?
Yes, we did.
Okay. And have you also spoken to the defense about your observations of that videotape and those photographs?
Yes, initially I was contacted at my home by Mrs. Blazier on September 1st, where I was told I would be coming back, which was news to me at the time. And then yesterday morning, during a break, I spent some time with Mr. Blazier, and then yesterday at the conclusion of court, I spent some time with Mr. Blazier.
Now, when you were here on other occasions, you took a look at the Rockingham glove, which has been marked 164A. Is that correct?
Yes.
Okay. And you also had the opportunity to take a look at the new Aris leather-like gloves marked 372C. Is that correct?
I'm not 100% sure what that particular style glove is. Yes, I've seen this before.
You were here for both glove demonstrations?
Yes, I was.
Okay. You told us that the style number of the glove at Rockingham and Bundy was an Aris 70263. Is that correct?
That's correct.
And you also told us that the new pair of gloves tried on by the defendant were also 70263s?
That's correct.
And the videotape that you looked at, and the photographs that you also looked at, why were you looking?
I was asked to look at these various photos and videos and try to establish whether or not they were the same.
What was the purpose of looking at them, sir?
To determine whether or not they were the same style as what was shown to me as part of the crime scene gloves.
And were you able to make a determination?
On some of them, yes.
And you also told us when you testified here in June that you in the past had actually manufactured, sold, marketed, and designed gloves for Aris. Is that correct?
Yes, I did.
Okay. You actually helped build factories, glove factories.
Yes, I have.
And you also told us that the Aris style number 70263 was a unique glove. Is that correct?
It was quite rare by comparison to all the gloves that I was involved in as far as production, design, and marketing. It was very limited in quantity and extremely difficult to make, very slow production. It was very distinctive by nature due to some of the characteristics of the glove, yes.
Okay. And are there certain characteristics of the glove that help you, as an expert, to identify the glove when you see the glove?
There are certain characteristics of the Brosser-Sewn style 70263, which in the design of the glove were built to make sure that it really didn't look like gloves that were less expensive. It was stated on the record, I believe, that the gloves were retailing at $55, and while to the average layman, a glove is really 4 fingers and a thumb, we had to be able to justify the fact that this glove was going to be retailing at $55.
Next one.
Well, the brochure stitching is unique to the glove.
Very.
Okay. How about the vent, the palm vent?
The palm vent is the least unique characteristic of the specific style in question.
Okay. But does the palm vent help you to identify the glove when you see it?
In conjunction with other characteristics, yes.
Okay. Is there something called a blind hem?
Yes, there is.
And what is a blind hem?
A blind hem is where at the end of the glove, at the wrist, the leather is turned over. A seamstress, usually very skilled, actually sews through the lining, through the hem on the inside, and then catches a little bit of the leather that would be toward the outside of the glove without going through the leather, and then comes back through and closes the seam, creating a very smooth, clean look at the back of the glove.
So it doesn't leave a hem on the outside of the glove?
It's not supposed to leave any identifiable marks on the outside.
Okay. And what about the leather used to make this particular glove?
The leather that was used in the Aris Lights program exclusively for Bloomingdale's was approximately 33 to 40% lighter weight than the conventional leather used in all the other production of men's gloves. It was approximately 0.55 to 0.6 millimeters in thickness.
And was there anything unique about the lining of these particular gloves?
This was the only leather glove style that was ever produced with a 10-gauge, very thin lining, which was one end of cashmere yarn, so that the entire glove package itself was extremely thin. All the other linings that we used were twice as thick.
Now let me direct your attention to the stitching on the back of 164A. Is there needlepoint stitching on the back hand, on the back of the hand?
There are 3 decorative points called draws on the back of the glove, yes.
And is that unique to the style 70263?
It's part of style 70263. Most men's gloves do have 3 points on the back or 3 draws. This particular draw is a 1, 2, 3 needle configuration without cord underneath to raise them. It's a flat point, but they are used on other men's gloves.
And you told us a little while ago, or a few moments ago, that you were able to determine whether or not some of the gloves worn by the defendant in those videos and photographs.
State of question, counsel.
You were able to determine whether or not some of those gloves in the photos and videos were in fact Aris 70263s?
Yes, I was.
And if in fact they are, they would be the same model and style as the crime scene in Rockingham glove, is that right?
That's correct.
Okay. I'm going to show you some videotape to start off. I'm going to start off, Your Honor, so the record is clear, with the Bengals versus Bills game on January 6, 91. Now, I'm not going to show you the entire tape. This is Exhibit 608, I believe. But I am going to ask you to take a look at certain frames, okay? For the record, the frame number is indicated on the video.
All right, Mr. Dart, if you would call those out when you start to examine Ms. Rubin as any particular frame, please.
Okay. Let's start at frame 248.
All right, Mrs. Robertson tells me that must be 607.
607, Your Honor.
607.
Okay.
Yes, 1691, Bengals.
Okay. Let's go to frame 2090. Seen this frame before, is that correct?
Yes, I have.
Looking at that particular frame and the gloves shown in that frame, can you tell us whether or not that glove, the glove the defendant is wearing, is a 70263?
Of the key features that would be part of identifying style 70263, on the right hand, the fine ridge stitching along the fingers, primarily the second finger, as well as the three-needle point configuration to the left of it, are the two identifying factors that I would use to say that this is style 70263. This particular Brosser sewing machine creates a stitch with approximately 22 to 24 stitches to the inch and creates a continuous ridge, which, when I eliminate the other kinds of sewing that I know about within the glove industry, that to my way of thinking, this can only be a Brosser seam.
Looking at that glove, do you see any water stains at all?
Mr. Darden, on this particular monitor, I can see a little bit, but as you know, I've had the advantage of looking at these photos and videos on small monitors and
Non-responsive. Next question.
Have you seen other, let's try that. Have you seen the same videotape on a smaller monitor?
yes, I have. Yes, I have.
And did that smaller monitor provide more clarity?
Yes, it did.
Okay. And when you looked at the same frame on that smaller monitor, were you able to see water spots or water
Yes.
stains?
Yes, I saw water that had been stained on the left hand, yes.
Could you tell whether or not the glove was absorbing that water or those water stains just by looking at it?
Yes, I could. In certain spots, it was absorbing water.
And how could you tell that?
Well, this particular glove is made out of naked leather, and at this point in time, it was in a position to absorb water or stains, and literally the staining of the water droplet made the leather in that area appear darker.
By the way, there was rainfall throughout this interview, was there not?
I've seen the video roll. Yes, there has been rainfall, and he's holding an umbrella.
Okay. And how about the fit of the glove? Can you tell us anything about the way the glove fits in this particular frame?
They're snug, but they appear to have fit fine.
Can I have one moment, John? Could you direct the arrow to the Brosser stitching that you referred to on the second finger a moment ago?
On the right hand, if you go down to the second finger and you see that fine ridge from left to right, right across the finger, it's about a 3-inch curve.
And you also mentioned the 3-needle point on the back of the glove?
Right to the left of it, it has the image of a 3-needle point.
Okay. Which hand are you referring to?
All right, 607A.
Okay. We'll next go to frame 1541. Okay, here we are at frame 1541. Can you see the Brosser stitching in this frame?
This is another version of the first picture. I can see some ridges on the top left finger that concur with what Brosser stitching would look like in a photograph.
What characteristics are there that relate to Brosser stitching that are different from other kinds of stitching that are done?
It's really the most continuous seam that has ever been utilized within the glove industry, to my knowledge. The other sewing techniques create high-lows or raw edge effects or continuous curved effects, whereas this is clearly a seam that is created by the sewing machine grabbing the two pieces of leather and putting them together.
Okay. And is that reflected in the crime scene glove, or rather the Rockingham glove that marked 164A?
Yes, it is.
And is that also reflected in the new pair of gloves marked 372C?
No, it is not. This particular pair was the pair that they produced with the same style number after they went out of production.
Oh, so that pair of gloves right there is not the same kind, the same type as the crime scene glove?
No, it is not.
How'd you know that?
That's what I did for 15 years, and it's quite easy for me to recognize it.
What is the difference between the Rockingham and Bundy glove and this later model, the later model glove that you have in front of you?
Even though it was manufactured with the same style number, 70263, the sewing technique is actually what is called 1/2 PK sewing, and it has a totally different effect both on the palm and on the back of the glove. And in this particular case, this isn't even the same leather that was utilized in the original gloves.
What is, let's strike that, how many stitches per inch are there to a brochure stitch?
Approximately 22.
And is that unique?
It's almost 100% more than all the... It's almost 100% more than the other conventional sewing techniques that exist, and in the case of a hand sewn, it's approximately 4 times the amount.
Let's go to frame 2425. Let me ask you to take a look at the fingertips, the ends of the fingers in that particular photograph.
Yes.
Does it appear that the defendant's hand, or rather that his fingers are fully and completely into the glove?
In this particular picture, one of two things have occurred. Either the gloves are not completely pulled down all the way onto his hand, or there's a little excess in the fingertip.
Now, when you were here last, you spoke to us about the length of the fingers in the crime scene and Rockingham glove.
Yes, I did.
And you also spoke to us about the length of the defendant's fingers.
Yes, I did.
And the size of his palm.
Yes, I did.
What size palm did you say the defendant had?
Mr. Simpson has a size extra large palm, and the fingers on both of his hands are size large. Technically, his real size is a cadet extra large, and this is where the actual fingers are approximately 3/8 to a half inch shorter than a conventional perfect extra large.
And so would you expect that if the defendant fully placed his hand into a glove, that his fingers would not reach the end of a traditional extra large glove?
In this particular case, as I stated for the record in my previous visit, there are definitely 3 different size extra large gloves, one being slightly undersized, one being exactly standard, and one being a little bit larger than standard. And for this exercise, I would say we have to use standard. In a standard extra large glove that was perfectly made for a perfect extra large hand, the fingers in that glove would be approximately 3/8 of an inch longer than Mr. Simpson would require.
And you do see excess finger space in these gloves?
In this particular photo, yes.
Let's go to 2585. So this frame depicts the defendant's left hand, is that correct?
Yes, it does.
Can you see any excess finger space in the left hand?
My monitor is very, very cloudy on this one.
So you can't tell?
Not in this particular one, on the monitor.
Let's go to 3357. In frame 3357, you can see the defendant's right wrist area, is that correct?
Yes, I can.
Is there a bunching up of the leather at the right wrist?
It appears to have somewhat of a gathered look.
And is that significant to you at all?
This would be consistent with a lighter piece of lightweight leather. The leather is not that rigid or firm, and you could easily get a gathered up look in a lighter weight leather.
And so this bunching up or gathering up at the wrist area, is that consistent with this glove being style 70263?
Yes.
Let's go to 4060. Okay, again, you can see the right glove, the right hand.
Yes, this is a closer shot.
Does the glove appear to have a snug fit?
Yes, it does.
And can you see the needle point on the back of the glove?
This particular shot shows me the 3 needle points on the back as well as the blind hem.
And is that consistent with this glove being a model 70263?
Yes, it is.
Let's go to 4443. Take a look at this frame, if you will. Can you see the defendant's left hand in this situation?
Yes, I can.
What, if anything, did you notice about the hem area, the palm area?
This pair of gloves appears to have a palm vent.
Is that consistent with the model, style number 70263?
Yes, it is.
Can you also see the needle point on the back of the right-hand glove?
Yes, I can.
And let's go to 4582. And what do you see in the left-hand wrist area?
This is a slightly larger shot of the opening of the palm vent on the left hand.
And 6777. You see any identifying characteristics in this photograph?
3 points on the left hand as well as the blind hem and the palm vent on the right hand.
You described for us a little while ago some of the characteristics unique to style number 70263. Is that correct?
Yes, I did.
Did you see each of those characteristics exhibited in these frames of this particular video?
I've seen 4 of the possible 6.
Okay. You saw the brochure stitching?
Yes, I did.
The palm vent?
Yes, I did.
What are the other 2 characteristics that you saw?
The palm vent, the blind hem, the 3 needle points, as well as the brochure stitching.
Did you see the cashmere lining?
I did not.
Okay. Now, this videotape is from January 6, 1991.
Come on. Let him go. This is ridiculous. Judge, do something about this.
Let's assume that we've heard testimony that this videotape is from January 6, 1991. At that time and on that date, did this glove come in a double extra large?
No, it did not.
Did you have an opinion as to whether or not the gloves worn by the defendant in this video are Aris leather lights style number 70263?
Based on what I've seen, I would say that this is styles 70263, size extra large brown, knowing that I had measured the defendant's hand.
And how certain are you of that?
I'm 100% certain.
Let me show you some photographs. I believe it's 605, the Rinker photographs. Check your list. Are the Rinker photographs 605 or 606?
I have 605 as being Mark Kruger. Rankin I have as 606.
We're going to go to 606, Your Honor. May I ask Mr. Rubin to step down, Your Honor?
Yes. Mr. Darden.
First, let me ask you to step to the side of the photograph, if you will, the photo board, to this one, between Ms. Clark and the board. Now, are these all? Do these appear to be photographs also taken from that January 6, 1991 game?
They appear to be.
Okay. And looking at the first photograph of the defendant with the umbrella.
Yes.
Do you see water stains on the gloves?
Yes, I do.
Can you see the brochure stitching?
Yes, I can.
Can you see the needle points you described?
I see the image of the needle points.
Is there a blind hem?
Yes, there is.
Is that style number 70263?
Yes, it is.
And would you also take a look at the photographs just to the right of the first one you just looked at?
Yes.
And if you will you turn around, please, and take a look at the photograph Ms. Clark is holding? That would be 606. 606.
Yes.
Are the gloves worn by the defendant in these 4 photographs the same style as the gloves found at Bundy and Rockingham?
Yes, they are.
One moment, Your Honor. Thank you. You can retake the witness stand. I leave the board in
Yes.
I'd like to go to the Kansas City Buffalo game, January '94, which is on laser, Your Honor. I'm going to go to the Stewart West photos at 12/29/93. Let me show you the photograph shown on the screen here. Those are black gloves, is that correct?
Yes, they are.
Looking at that glove, can you tell us whether or not there are any characteristics that are consistent with an heiress style number 70263?
This is a very clear picture of the brasso stitching on the right-hand forefinger, as well as the three-needle points. There's a blind hem, and in addition to that, it confirms that this leather is very lightweight, the way it's actually folded over in that one spot where it's bunched up. You can see that they're very close to each other, so it's a very, very thin glove with thin lining.
And this is frame number 31175 for the record, Your Honor.
Yes.
And if you'll just step down for a moment. Take a look at the photographs taken by Stewart West on December 25, 1993. Yes.
Yes.
Looking at those photographs, can you tell us whether or not the glove worn by the defendant in those photographs is style number 70263?
Yes, it is.
And your opinion is based on what, sir?
The fact that the three most important elements of the design of the brasso stitching, the 3 points in the blind hand, and those are the 3 elements I can see in this picture.
And while you're here, let me direct your attention to the photographs taken by Michael Romano. There are 2 photographs to the right of the board depicting the defendant wearing black gloves. Is that correct?
That's correct.
And also on frame 30706, Your Honor.
Yes.
Do you see the 3 needle points you described earlier
Yes.
in both photographs?
Yes, I do.
And in both photographs, do you see the brochure stitching?
Yes, I do.
Is there a blind hem?
Yes, there is.
Can you see the cashmere lining?
In the blow-up on this photograph on the right, the beige lining, it is cashmere.
Now let me show you the gloves the defendant tried on, the new gloves, People's 401.
Yes.
Is there an heiress tag in those gloves?
Yes, there is.
And how does
If
that
there
tag
was an
compare in appearance
autopsy,
to the tag
there
that
would be
you
no
see on
coffee
Michael Romano's
found.
photographs?
In like
Rephrase the question.
Well,
couple days,
on the Michael Romano
maybe a
photographs,
week
do you
or
see
more.
a tag?
Yes, I
because I
do.
need to buy a house.
Can you tell us whether or not that tag is an heiress
So I
tag?
did not drink
I
your
believe it is.
coffee.
And what is it about the tag that leads you to believe that it is an heiress tag?
All of the Irish leather gloves that were made in production for many years contained a printed Ross patch printed label with beige material with burgundy printing, which determined the it had the size, the country of origin, did not include the style number, and it had the Irish logo with double chevrons, and it was framed in a box in burgundy, just as this is. And this one, says 100% cashmere, made in the Philippines, size extra large.
Okay, he's referring to 401, Your Honor, for the record. Does the tag...
All right, guys, we made it. Made it to the end of OJ for today. I have a question, since there's some people here. I have a video that's not in front of me right now. When OJ was older, he did go to jail for a couple years. I'm banging my head. It was either 4 or 9. I think it was 9. I have the parole hearing for when they released him from jail when he was much older, right? We are on video 449. We are almost at video 450, okay? Let me see. I mean, we'll definitely hit 450 tomorrow, unless we take a field trip and we play his parole hearing to be released from jail later in life. He's much older. We don't have to. I don't know if it's good, bad. I have no idea. I am too, Josh. I am too. I mean, we don't get to hear him speak at all during this trial. And I'm wondering if the parole board in the later case will bring it up. But we know we're going to hear him speak, because you don't get released from parole until you tell them, you know what you did was wrong, and you've done this, this, and this to be a better person, blah, 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 blah. So, I got 1 vote for yes. Unless I get a bunch of no's, I'm going to do it tomorrow. So, we'll do that. It's like an hour and a half long. So we'll still be doing a little bit of OJ tomorrow, which means we will not finish 449 tomorrow, but we'll get mostly through it. All right, guys. Have a great day. I hope all your plans go well today. I will see you all again very soon. Bye, guys.